Physicians for Social Responsibility Colorado is honored to introduce Attorney Randall Weiner of Weiner and Cording, Boulder, Colorado. Attorney Weiner has a long history over several decades representing citizens and citizens groups on Rocky Flats issues. Currently, he is representing 2 cases before the Appellate Court. PSR is plaintiff in one of these suits. We are grateful for his knowledge and dedication. Thank you, Randy.
Hello, my name is Randall Weiner. I'm the attorney for environmental and citizens groups involved in 2 separate actions involving the Rocky Flats National Wildlife Refuge. The first is the case against the U.S. Fish and Wildlife Service that has been going on since 2017, almost 5 years now. And in that case, the agency opened up the refuge, and we believe did it without complying with the National Environmental Policy Act, leaving out certain documents that showed how unsafe the refuge was, and in violation of the Endangered Species Act. We held a preliminary injunction hearing in July of 2018 on that case, and many of the speakers that you're hearing at this symposium were witnesses in our case, in our attempt to prevent the opening of the refuge. And the judge ruled against us and ultimately ruled against us on the merits. And we are now in the 10th Circuit Court of Appeals appealing Judge Brimmer's decision. Oral argument is scheduled for May 18th, and the public is welcome to attend. And that case will be before 3 10th Circuit judges. We don't know their names yet. Our second case involves the Rocky Flats National Wildlife Refuge, but was only filed last year. And that's a case in state court against the city of Boulder for allowing its open space lands to connect directly to the Rocky Flats National Wildlife Refuge and the Greenway, which is a bicycle and trail system envisioned for an area from the plains to the mountains. And the 2016 Boulder City Council mandated that before that connection occurred, that the city council and city staff look at alternatives that avoided Rocky Flats, that circumnavigated the refuge. And indeed, there is a way to do that, to connect Boulder open space lands with Broomfield open space lands. Yet the city went ahead with approval of the connection without undertaking that alternatives analysis. So we have sued, as I mentioned, the city of Boulder. The city of Boulder argued that there was no jurisdiction to complain about their actions. And the lower court dismissed our action on jurisdictional grounds. We are before the Court of Appeals, the Colorado Court of Appeals, to challenge that decision on jurisdiction and to try to get back into the court so we can argue the merits of that case. I want to let the audience know that we have briefing on those cases at any point from during today or at any point in the future. You can ask for briefs and our office will send them to your email address. Since I have a few more minutes, let me speak about the merits of our case against the U.S. Fish and Wildlife Service. Under NEPA, an agency must conduct an environmental impact statement for any major action that impacts the environment. In this case, the agency, the Fish and Wildlife Service, did what's known as a categorical exclusion, saying that there was no action that required analysis. We disagree. The new trails that were proposed for the refuge went through what's known as the Section 16 parcel, an area that had never been examined for radioactivity. And one of the trails went through the windblown area, the most heavily contaminated portion of the refuge. That was significant because previous directors of the agency had a policy of preventing public access to that windblown area. It was only the new director and the new regime that decided to put a trail directly through that area, which we believe is dangerous. And no court has ever looked at that issue. The agency hadn't looked at the issue. And we believe that was a violation of NEPA. The other arguments are under the Endangered Species Act. The court below claimed that we didn't have standing, even though one of the speakers today, Randall Stafford, argued or testified that he was going to use the refuge and that that he had an interest, and that should have met the standing requirements. So we want to review under the Endangered Species Act. The court below also approved not expanding the record to look at some of the important documents which showed how heavily contaminated the refuge was, as well as the agency's prior policy of not allowing people to go to the windblown area. We look forward to seeing you at the hearing or reading about our results. We are optimistic that with an impartial panel, we will have a reasonable review and a good chance of success. Our case against the Fish and Wildlife Service, the first case, has as plaintiffs the Rocky Mountain Peace and Justice Center, the Environmental Information Network, Candelas Glows, Rocky Flats Glows, and a couple of local environmental groups. Our case against the city of Boulder, the second case I spoke about, has as plaintiffs the Physicians for Social Responsibility Colorado, again, the Environmental Information Network, and Harvey Nichols. Thank you, and please contact us if you'd like to see our briefs.